Well, if it's 6 o'clock on a Thursday night, this must be Steven Leskin and One Day Divorce Mediation and my deep dive series. Thank you for joining me. We have a number of people from out of state who are on the video tonight with us. Um, so let's get into it. Tonight's topic is mediation and domestic violence. And uh, domestic violence um, uh, in mediation presents some special problems. It's not like litigation where you come into the courtroom and you sit down and you just talk to the judge. Mediation can be face to face, or it can be in separate rooms, but the dynamic is different. The point I'm driving at is the dynamic is different, and that's what we're going to explore tonight. So our agenda is, I'm going to talk about myself a little bit. Then we'll talk about basics of mediation. So just so that everybody has a sense of we're all on the same page about what goes on at mediation. Then we'll talk about domestic violence and what that looks like and can look like. We'll talk about what to expect from a mediator, how to prepare for mediation, and then finally, uh, divorce, domestic violence, and litigation versus mediation. And finally, just there's some collateral issues I want to cover just for the sake of completeness. That was me scratching my nose. Uh, so during these seminars, I don't like to take questions, but I'm happy to take calls or respond to emails later. So please take my contact information, and if there's a question that comes up, I'm happy to respond, um, just not during the seminar itself. Tonight's seminar is a little different from other seminars that I've done. I do on divorce topics. Tonight's um, seminar was broadcast to the mediation community. So I'm trying to pitch it both for professional mediators and for the public at large. And I hope I get it right. But if it's not talking directly to you, it may be because I'm talking to another group of people. But the subject matter is all the same. But there's just a little detours here and there to accommodate the two groups of people. Um, like I said, there are people, the invite listing or the registration list included multiple people from out of state. So there's not going to be a lot of legal talk in this mediation, unlike in this webinar, unlike in other webinars that I do. Uh, so the general framework and the general points I'll be making will apply to everybody, regardless of where they live. And then there's a couple of times when I'm going to be referring to like the Oregon revised statutes. And when I do, those just don't apply to people who are not in Oregon. Last thing I want to say before I jump into it is I really view these as a community resource. I really try to create something that people can look at and learn from. And I've discovered that the more information that people have um, during their litigation process, the better decisions they'll make and the less stress they'll have, and the more efficiently things will go, particularly if both spouses are on the same page about what the law is. I do not try to do these as infomercials. I rarely refer to myself or my practice during these seminars, but since I do divorce mediation, I will be talking about my experiences and particularly how my process addresses some of the issues. Again, my intent is really not to do this as an infomercial, but just to showcase um, various points that I'm trying to make, uh, because my process addresses those points. And so we'll get into that a little bit during the webinar tonight. A little bit about me. My name is Steven Leskin. I've been admitted to practice law in Oregon since September 18th at about 2 o'clock, 1992. I opened my solo practice around 3 o'clock in the afternoon in Hillsborough, practicing law ever since. I've been practicing family law since 2001. I'm the founder of One Day Divorce Mediation, a mediation practice in Portland. I do mediations with my One Day Divorce Mediation process all over the state through Zoom. All right, let's get into it. Enough small talk. Basics of mediation. So what is mediation? Mediation is a process of finding constructive solutions with the assistance of a neutral third-party professional. So mediation is the opportunity for uh, people who are not in agreement, whether they're in litigation or it's community or family, to resolve their conflicts directly and resolve their differences correctly. A mediator is somebody who is trained, and a neutral who will go back and forth between the parties to help them devise a solution to their own conflict. Litigation is also another way to resolve conflicts, but that involves a court, rules of evidence, witnesses, uh, testimony, oaths. It is a much more cumbersome fact-finding process where competing versions of events um, are uh, different competing events are used to decide what the outcome is going to be. So, uh, with mediation, the final results rest with the participants. With litigation, ultimately, the result rests with the judge. Uh, with a judge, you may not get the subtlety or the finesse that you want. Uh, some judges are good, and you get more subtlety and finesse than you bargain for. Uh, um, but with the judge, the decision is ultimately out of your hands. So sometimes that's appropriate, and sometimes that's good. Uh, but I think most people prefer to keep decision making and the results within their own uh, hands. Another difference between mediation and litigation is that mediation is a consensual and voluntary process. The parties have to agree to be there. Um, Even in situations where mediation is court ordered, you do have to show up, but you do not have to come to a result or an agreement with your spouse. It's oftentimes just enough to show up and say, "I'm here to mediate," and then you satisfy the obligation. It is a voluntary mediation is always a voluntary process. Uh, and then the final point I want to make on this page is that mediation rules are generally agreed to by the parties. And this is one of the places where I'm going to talk about my own practice, just as a way of illustrating. When participants agree to work with me and go through my mediation practice, one of the first things that they do is they sign onto the rules that I'm proposing. Part of my onboarding process is here are the rules, and you need to be familiar with these. You need to at least read them because this is what we're sticking to. And so the rules will outline, for example, what the confidentiality requirements are. The rules will outline how the mediation will take place. The rules will outline what happens if somebody fails provide evidence. So, for example, if somebody has a retirement account and they don't want to provide a value to divide that retirement account, my rules provide what will happen in those situations. So the rules are agreed to. If you don't want to do my process, then you don't have to sign my rules. But if you do my process, you are going to agree to do the rules. And that's what we stick to. That as the mediator, that's what I'm enforcing during the course of the mediation. Just a moment ago, I said that mediation is mandatory in uh, if you go to mediation, it's mandatory, and in family law cases, that's true. In all cases in Oregon, if a case is filed in Oregon, every case, almost every type of case, is uh, subject to a mandatory um, it's mandatory that they go through some alternative dispute resolution, which means you have to sit down and talk with the other litigant to try to get the case resolved before it gets to the judge. The three types of alternate dispute resolution, I think it's generally not just in Oregon, are mediation, arbitration, or judicial settlement conference. Uh, Mediation we've talked about. Arbitration is where parties agree on a arbitrator who then acts as a judge, will take evidence and then listen to the parties and then make a decision on the case. In Oregon, that is mandatory, which means that if you don't agree with the um, arbitrator's decision, you still have the right, you have the constitutional right to a jury trial. So if you don't like what an arbitrator agrees, you can still get your trial. And then a judicial settlement conference is uh, with a judicial officer. Maybe it's a judge, maybe it's not a judge, but through the court, and it's somebody with experience who can look at a case and say, this is, I think, where it's going to come out. So it's a little bit different from mediation. Judicial settlement conference, you're asking for the judicial officers' um, take on, how you think the parties are going to come out in a case. In Oregon, in family law cases, each county determines the criteria for which type of cases will participate in mediation. In Multnomah County, mediation is required when children are involved. You have to mediate. You have to talk to your spouse about issues related to the kids. Excuse me. In other counties, everyone uh, must mediate whether or uh, uh, there are children or not. I didn't say that right. In other counties, mediation may be required regardless of whether or not they're children. So if you filed a divorce, for example, in another county, you still may need to go through the mediation process. Um, Divorcing couples can satisfy the requirements of mediation through going through a private mediator or going through the courts. And the court, there's usually a small charge um, to go through mediation, uh, going through a private mediation, going through a private mediation one more time. Going through a private mediator will definitely be more expensive. But the advantage is that some of the private mediators are very, very good at what they do uh, and will really help the parties get to a settlement. That is not to say that the court mediations are not very good. They are excellent. I've had many, many, many interactions with them and have been very impressed with how well they've done. I've had clients who I've sworn they will never get an agreement through court-sponsored mediation, and they call me up and say, "Hey, we got it done," and terrific. That's great, and that's done because a lot of the public mediators to the courts are very, very good at what they do. And my experience is that oftentimes it is a worthwhile process. Format of mediation. So mediation can be conducted by uh, lawyers. It can be conducted by therapists. It can be conducted by other generalists. There are people who are professional mediators. Uh, Whether or not you want to hire somebody who uh, has a specialty is, I think, probably the first question you want to ask. Uh, as a divorce lawyer, I know how complicated Oregon divorce law is. I know what it takes to get a uh, final divorce decree through the courts. I know all of the laws that go into two things: the content and the process of making that work. So my prejudice, just knowing how complicated things are, is that uh, mediation in family law cases be conducted by a lawyer. Um, Mediation is not therapy, and it's the divorce. Let me start from here. Divorce is the dividing of the assets, future income, liabilities, and dealing with the kids at the time of trial. So it's about property division and kids, and um, for those reasons, lawyers understand that that's what's going to be done. So and the rules that the courts will impose to get there, and I think that knowledge will help parties get a result in the end. Um, There are generally two formats to mediation. One is where divorcing couple sits around a table and they talk through the mediator. The mediator facilitates the discussion, keeps people on track, make sure that um, the rules are observed, make sure that people don't descend into ad hominem and that they keep the conversation constructive and positive. Or the other format is putting participants in two separate rooms, and then the mediator shuffles back and forth between the two rooms. Sometimes mediators will use a combination of both. Maybe they'll start out in separate rooms and bring everybody together. You can do that on Zoom as well. Or they'll start out together and move into separate rooms to discuss things confidentiality. And that happens in the Zoom world as well. Um, uh, my mediations are conducted almost entirely over Zoom, and I was a little skeptical at first about how it would go, but I've found that people like it. People like to be able to get up and walk around. They like the privacy and security of their own homes. Uh, they prefer to be in their kitchen as opposed to a lawyer's office with nothing to do. So, or just scrolling on their phone. So, I've actually found that uh, Zoom to conduct mediations actually has worked pretty well, and I will continue to do that. Uh, I will note that if somebody calls me up and says that they want to do a live mediation, I'm happy to do that. I've done that often, but it just seems that the Zoom format works really well. Okay, so we've been talking about mediation. Let's transfer now to transition to domestic violence. Forms of abuse. Forms of abuse. Just it's amazing to me how many ways people can find to hurt one another. There's obviously physical abuse and physical violence. There's emotional abuse, financial abuse, psychological abuse, sexual abuse, digital abuse. Uh, all of these revolve around one thing, and that is power and control. Each form of each form of abuse has at its core power and control of the other person. Um, Abuse can be cyclical. Abusers can go from warm and loving to abusive over time, and the transition back and forth between a caring spouse and an abuser, um, besides just being plain old manipulative, leaves the abusive person confused. It leaves the abusive person hopeful. There is often just enough hope that the victim doesn't want to leave the relationship, uh, and so um, the abuse is a dynamic part of the relationship that leaves its scars ongoing and builds within people until we'll cover impact, but until uh, there's loss of confidence, loss of self-respect, uh, breakdown in social relations, breakdown in financial controls. Abuse can have a global impact on a person. Uh, I would just point out, it just bears saying that neither gender has a monopoly on abusive behavior. I do want to point out that I do want to talk for a little bit about a mediation I conducted just 2 weeks ago, where the wife kept telling me about how abusive the husband was. And so immediately I put them into separate breakout rooms. When I met with wife, uh, I came and said, all I'm going to do is bring you his proposals. All we're going to do is focus um, on on getting you guys to agree. After the mediation was done, they came to an agreement. I was happy they came to an agreement. Uh, she just was lashing out at him horribly via email, and my perception of the dynamic shifted after the mediation. He was okay. I didn't have an issue with him. I didn't particularly feel like he never engaged in ad hominem, never raised his voice. Uh, Pretty much stuck to the forms. But in after uh, the mediation was done, I had to do a little bit of more re evaluation. It didn't matter. the work was done. But I think the takeaway is you have to always keep an open mind and be sensitive to the dynamics of what's going on, and be careful not to replace your own judgments with the party's judgments, right? So just keep an open mind and be sensitive to the issues during the course of the representation or the mediation is paramount. Impact of abuse. Physical health may be compromised directly and indirectly. Uh, Physical health may be compromised directly through physical wounds and indirectly through heart conditions, stomach conditions, things that just react to from years of abuse. There's psychological and emotional trauma in the forms of depression and anxiety. Social and relational effects include isolation, mistrust, and fear. Financial consequences include lack of resources or excessive debt. Those aren't obviously exclusive. Financial consequences include resulting from manipulation of money, one person hoarding family's assets, party not having access to the either to the resources itself or significantly to the data. So not having access to bank accounts, retirement records, credit card records, things like that. That's also a form of abuse. Some people don't want to know, uh, but there are other people who they take care of it to keep the data and the information to themselves as abuse. All other impacts include impacts on children and family dynamics, including alienation from children and unhealthy modeling later in life. Let's talk about what to expect from a mediator in context of domestic violence. A mediator needs to create a safe environment. Uh, Keeping the parties separate may be paramount. Clarifying confidenti- confidentiality obligations. Mediators should discuss safety issues and create a safety plan, including before, during, and after the mediation. Uh, the mediator's focus needs to be on effective long-term solutions, particularly if there are children involved. A mediator needs to keep the mediation focus on not the history, but the present and what's before the parties. Uh, During the mediator needs to police for intimidating context, comments, and gestures, and then attempt to balance the unequal power dynamics while remaining neutral. And you do this by focusing on interests rather than positions. So what is the bottom line interest? You can talk, for example, about um, both parties having uh, parenting time, and dad wants it this time, mom wants it that time, or you can talk about how they're going to create the relationships that they each want with the kids. That's the interest, and then get into the specifics of the parenting time. Uh, Keeping it focused on interests is also a way of um, trying to balance the power dynamics, because you talking about interests, not, well, I want the kids all of the time. Uh, and then one of the most important things is always maintain neutrality for the benefit of both parties, even when responding to the underdog. We all People in mediators tend to, they want to help people. We're in this profession because we want to help. We want to do something positive, but we can't let that um, undermine your neutrality. Your the temptation may be to reach out and try to support the underdog, and that's fine. But you have to still do it in a neutral way, which is of course challenging. But that's the challenge, is balancing that neutrality um, with trying to create a level playing field for both of the parties. Um, Let me move on. Spotting DV in the office. So for the mediators in the audience, hello. Uh, um, the state of Oregon is working on developing new screening criteria for domestic violence. I understand that those new screening criteria will be complete before the end of the year. The Oregon Mediation Association Conference in November will have a speaker who gets into that, who gets into the new screening criteria. So um, that's just something to look for coming down the road in the not too distant future. Um, and or mediator, somebody who's sensitive to domestic violence, is looking for the intimidating gestures by the abusive party, or the off comments or the glances, um, and will react to that either by calling it out or by separating the parties. Uh, Conversely, looking also for signs of fear and anxiety and withdrawal by the victim. Um, you're also looking for media will also look for who's dominating the communication and whether or not both parties get about equal time. Uh, and then there's also manipulative touching. You know, the touch that indicates that somebody's gone too far or needs to be quiet. I will say that when I am either representing a client in my practice or even when I'm talking with somebody who I know that where there's DV in the relationship, I will, as a matter of course, I will say, um, I will tell people, I really want to be sensitive to you. I don't know your whole experience. I don't know what will work for you, and you should be free to tell me that. If I'm doing something or saying something that isn't working for you, I want to know. I want to do it right. And I've found that by saying that, people know that I'm receptive to hearing them. I've given them permission to speak up. And that just, people appreciate hearing that. You're acknowledging their experience. You're not substituting your own experience for theirs. And um, it's just part of the process of trying to get it right. So it is okay to put that on the table. I and really that's what I say. I say, I don't know your experience. I'm happy to learn about it. If I'm doing something that's not working for you in light of your history with DV, then just tell me and I'll work on it and I'll do my best to get it right. And people appreciate that genuineness and sincerity when it's there. Okay, so we're going to talk about how to prepare for mediation in context of DV. Okay, so in my book and the way I do mediation, mediation is not itself a fact-finding process. And here I'm going to talk about my own process a little bit. For me, when I sit down with a couple to do mediation, I want all of the facts of the marriage agreed to before we get to the mediation. Mediation is for negotiating where those facts are going to go, where those assets and liabilities are going to go. But I have a very definite prep period and a very definitive process that I go through with a couple to figure out um, what the assets are of the marriage, what the income is, what the debts are, what the value of houses are, for example, or retirement accounts or whatnot, and income of the parties. I want this established. It's important to my process that that is established before the parties get to mediation. So at the mediation, the parties aren't going over, well, I think the equity of the house is X, and the other spouse says, no, I think it's Y. You're not going to resolve that within the mediation. If you are at that impasse that there's $100,000 difference in opinion about what the equity of the house is, the mediation will have to continue on, right? You're not going to finish up the mediation in one day or one afternoon if you do that. The time to do all of that fact finding is before you get to the mediation, and um, you want to come to ideally you want to come to an agreement with your spouse about all of that before you get to mediation. In context of DV, you're not going to be able to do that if the couple if there's DV in the relationship and that's broken and the DV is broken down communication, you're going to have to do that through a third party, right? And maybe it's not, maybe you're not going to get to an agreement on the value of a home, but at least you can come up with values for what all of the debt is. You can do all of the discovery so you know what all of the debt is. You can, if spousal support or child support is an issue, you can gather up all of the documents you need for both parties to establish what income is. You can do that beforehand. Um, and again, if there's DV, you're probably going to need to do that with a third party. Um, in litigation, both sides are entitled to, 3 years of tax returns and a year of um, credit card statements and 2 years of this and 3 years of that, and every certificate of deposit and every certificate of title. Uh, I only require those when there are differences of opinion. So, um, uh, if a party thinks that the savings account has $20,000 and the other party thinks that it has 10,000, then I want to see a bank statement. It's easy enough to figure out, um, and you want to do that ahead of time. Establishing the facts ahead of time allows the mediation process to find solutions, not facts. So, uh, in DV context, you still want to go through that, but you want to do that with a third party, and particularly somebody who's familiar with the process and knows what has to go into the divorce decree at the end. With DV, where there's that breakdown in trust, mediation may not be appropriate, uh, particularly if you cannot trust your partner to disclose all of the assets, all of the liabilities, all of the property, all of the income. If you can, if you cannot um, trust your partner to disclose that, then mediation is not appropriate. I think that parties can mediate where there is domestic violence, but you can still have domestic violence, as crazy as it sounds, and trust that your partners put all of the assets on the table. I've seen couples do that. I've come away with confidence that the final result was fair and honest. But if a spouse says, I haven't seen any of the records, I don't know what's in the bank accounts, I don't know what's in the retirement accounts, my partner has kept those for me, I've never seen them, then mediation may not be the right venue for a divorce. In litigation, an attorney has the power to subpoena a witness or documents to a deposition. You can put somebody under oath at a deposition and say, "I need to know all of your all of your banks," and there's penalties if there's non-disclosures. A mediator doesn't have that power. A lawyer has the power to subpoena somebody, to subpoena records, uh, and get those statements under oath. Um, so, um, if a party cannot trust the other party, then mediation is not the right venue. Uh, I think I legitimately think that most, even if there's violence, even if there's abuse, you can mediate, and mediation may be a better option than going to trial and going through court and hiring a lawyer. That process could take a year. It's expensive. It's more adversarial. It creates more of an adversarial relationship between the parties. The lawyers are paid $300 or $400 an hour to make the other side look bad, and that's what you get paid to do. So that does not create a conducive environment going forward. It poisons the relationship even further. Mediation does not do that. So um, I think that mediation can be useful where there is DV, but again, it's a really big caveat. Not if the partners can't trust one another to disclose all of the assets of the marriage. Another way to prepare is understanding the law. Again, I'm going to refer to my own practice. When I sit down with a couple to prepare for the mediation, we do a pre-mediation conference. I explain the law to people. I understand. I explain how a court will decide on spousal support or divide the debt. And I have found that once people have this knowledge, that they can make their own decisions. And once explained to both parties at the same time, um, uh, they have guidelines to know that they're not going to get taken to the cleaners, they're not going to get screwed, that they're going to get a result that they would have gotten in court. and that empowers people to make their own decisions and helps them come to um, an agreement between themselves without going to court. So I am a real proponent of even if you've agreed to mediate, understanding the law is important. Uh, the way I do mediation is if a party can't agree, I step into the role of arbitrator and I decide. If you agree to arbitrate, if you agree to mediate, you still may end up in court. But it's important to know that you are taking a reasonable position based on the law uh, when you mediate with your spouse. You don't want to end up in court because your position was unreasonable and it's something that the judge never would have agreed to. So, for example, uh, you may take a position that you want 50% of your spouse's income for spousal support. Judge not likely going to do that. So, having like some realism in your thinking and knowing what the law is uh, guides gives guidance and some certainty and helps you negotiate and advises when you should um, play your cards or fold. It may well be worth it to spend money for a consultation for an attorney or hire a lawyer to advise you during the mediation uh, or find, reputable information online. And just, you got to be really careful what you're looking at. There's a lot of bad information online. Uh, my website has a ton of information that I've recorded. There's a ton of videos. There's a ton of other attorneys who do in Oregon who are very competent attorneys who also do mediation. I misspoke. Who also do videos and have resources online. Go look those up, but make sure that you're looking from somebody who's in practice, been practicing for a long time, and knows their stuff. Have a plan going into the mediation. This is particularly important if there's DV. You want to avoid. You want to be able to do the plan in the quiet of your own home and then know that this is what you're going to stick. Know what your trigger points are. Know, most of us have a pretty good idea of a couple of years into a relationship how we're being manipulated. Know when you're being manipulated. Know how you're going to deal with that. Um, but have a game plan going into to the mediation, knowing what your hard no's are, knowing what you're willing to give up, what you're going to give away, knowing where you want to be flexible and where you don't. Uh, Talk to somebody who can give you objective feedback, right? Talk to a friend. Uh, and you want somebody who won't simply validate your positions. You want somebody who will push back a little bit. A lot of times, our friends see their roles as validating us, but that's not what you need. You need somebody who's going to say, I think you're asking for a little bit too much. I don't think you're asking for enough. So you want to get objective feedback from people who know, not just who are going to, be yes people. So have a plan going to mediation. That plan includes knowing your hard nose, figuring out where you're going to get triggered, figuring out where your spouse can manipulate you. And once you have that knowledge, once we know we're being manipulated, it becomes easy to say no because then you're making a choice. Well, I'm not going to let you manipulate me like that. So, uh, think about that. Where your vulnerabilities are, and include that in your plan. Uh, So have a game plan going into the mediation, write it out. Know, for example, if you are asking for spousal support, make sure that you have the grounds for asking for it. And make sure that you have the grounds for uh, knowing what's a reasonable amount to ask for, and that you're not going to go below that unless you're getting something else and you have a reason to. But generally, you're not going to cave on your nose. All right, so let's talk about restraining orders and how they impact domestic violence. Um, there are multiple different types of restraining orders and no contact orders, and the effect is the same. For example, if there's a Family Abuse Protection Act order, that prevents a couple from communicating directly or indirectly for 2 years. You have to go to court. Even if you hire a lawyer, the best practice is to go to court and get that non-contact uh, order modified so that you can conduct the mediation, particularly if there's an attorney involved. Uh, um, the Oregon State Bar recently issued an ethics opinion that it was a violation of an attorney's obligations um, not to not adhere to a court order by speaking with somebody who was on the other side of the FAPA, on the other side of the Family Abuse Restraining Order Act. Unbelievable. That's what attorneys are for. You have to make communications, especially if they're children. Uh, so the best practice is to make sure that your client has language in the restraining order that the attorney can speak to the spouse. If there's a stalking order or some other harassment or something else where there's a no contact order, um, the best practice is to go back to court, file a motion if you have to get the court to modify the no contact order so that the parties can engage in mediation and the mediator can speak to both parties and then have the parties together. You want to avoid any kind of like allegation that there's been indirect contact. So the mediator has to be covered in that situation as well. Um, you need to modify this before you engage in mediation. Over the years, I've done a number of um, uh, civil agreements between parties, and you can do that. And the civil agreement will say that if both parties agree to mediate, that any contact during the mediation will not be reported, uh, that it will not be considered an offensive. It will not be considered an offensive. I misspoke. It will not be considered a contact under the restraining order, and that the neither spouse will report this to the police as a contact. And I've done that a number of times. My practice now is to just go and get now it's just to go and get the uh, uh, restraining order modified. Thank you for participating. I hope this covered what you were expecting and was informative for you. My contact information is on the screen. I am happy to take questions. Give me a call, shoot me an email. If you have comments, I always want to hear them. If you want, we live in an age where you need to be liked. You know, somebody else has to validate you by liking you. But if you like this, please validate it on Google. Write me a review on Google, or give me a review on Meetup if you found the seminar through Meetup. Again, thank you for attending, and we will be back online in 2 weeks. So I think that's it. I think I'm out of things to say. Thanks.